This is Barry Zalma on Insurance. Today I'd like to speak about the duty to defend when there is no loss to tangible property. The COVID-19 pandemic has resulted in multiple lawsuits dealing with the need for actual, tangible damage. For example, in a class action attempt that failed for lack of direct physical damage, Carib Restaurant and Nightclub initiated a class action against defendant Topa Insurance Company, alleging breach of contract and seeking declaratory judgment for insurance coverage. The United States District Court ruled on a COVID-19 business interruption claim in the case called Carib Restaurant versus Topa in 2021. As of almost every court in the country, it ruled that there must be tangible damage. Carib owned and operated La Luz Ultra Lounge, a restaurant and nightclub located in Bonita, California. Carib purchased an insurance policy from Topa. In March of 2020, due to the COVID-19 pandemic, the state of California and County of San Diego ordered the closure of bars and banned on-site dining. In May of 2020, San Diego County permitted the resumption of on-site dining, subject to restrictions. Carib alleged that as a result of these civil authority orders, it was forced to suspend or reduce business at La Luz. Carib also alleges that COVID-19 impaired Carib's property by making it unusual and unusable in the way that it had been used before. Carib alleged that its losses were covered under the policy and identified 4 specific provisions: business income, extra expense, civil authority, and duties in the event of loss, which is referred to as the sue and labor provision. Carib filed claims for coverage under these provisions, which Topa denied. Accordingly, as to be expected, Carib sued Topa, asserting that denial of coverage was a breach of contract and sought declaratory judgment. Topa argued the policy provisions Carib cited provide coverage only for, quote, direct physical loss of or damage to, close quote, Carib's property, and Carib cannot recover under any of these provisions because it failed to allege any direct physical loss of or damage to the insured premises. Carib, on the other hand, insisted that it had a sustained direct physical loss of its property because it was forced to suspend or reduce business at its location due to COVID-19 and the resultant safety orders. Every policy provision at issue contained language conditioning recovery on physical loss or damage to the property. Indeed, the business income provision stated that coverage is conditioned on the necessary suspension of business operations caused by direct physical loss of or damage to the insured property. Thus, the question before the United States District Court became whether Carib had alleged physical loss or damage sufficient to trigger coverage under one of these provisions. Under California law, losses from inability to use property do not amount to physical loss of or damage to property within the ordinary and popular meaning of that phrase. Further, only a distinct, demonstrable physical alteration of property will amount to physical loss or damage that may trigger coverage. Detrimental economic impact alone is insufficient. Several courts in this jurisdiction have recently considered cases with facts nearly identical to this one, and these courts have reached a consensus. Where an insurance policy conditions recovery on direct physical loss or damage, economic business impairments caused by COVID-19 safety orders do not fall within the scope of coverage. The policy provisions on which Carib relied clearly condition recovery on physical loss or damage to the insured premises. Carib alleged only that COVID-19 restrictions have prevented it from using its property for normal business operations, which it claims is direct physical damage. However, Carib did not sufficiently allege direct physical loss or damage such as would trigger coverage. Therefore, according to the United States District Court, Carib's failure to allege direct physical loss or damage forecloses its claim to coverage under the policy. Nevertheless, Carib contended direct physical loss should be read to encompass the type of economic business impairments it has suffered, even if the policy covered permanent dispossession, which it does not. Carib has not alleged permanent dispossession, nor could it, as COVID-19 safety orders only temporarily restricted Carib's use of its premises. While the court was sympathetic that Carib is suffering economically from the unprecedented COVID-19 pandemic, an economic business impairment does not qualify as a physical loss or damage to the premises. Because Carib did not allege direct physical loss or damage, its claims were not covered, and its causes of action for breach of contract and declaratory judgment failed. Therefore, the court granted TOPA's motion to dismiss without leave to amend. As sad as the COVID-19 losses are, and as expensive as they are to businesses like Carib, a court has no right to, nor will it change the wording of the policy. The damage done to Carib and those similarly situated was done by the state of California. Failing to obtain insurance benefits was expensive to Carib, but perhaps some creative lawyer will find a way to sue the state for its wrongful and allegedly unconstitutional orders depriving Carib of the right to do business. The Supreme Court of California, in a case called Kazi versus State Farm Fire and Casualty, found that a CGL insurer only owes a duty to indemnify if there is damage to tangible property. The court stated, quote, "A standard general liability insurer has a duty to defend and indemnify for a loss to tangible property only. The property loss section of these policies provides coverage for physical injury, loss, or destruction of tangible property, and the focus of that property damage coverage is the property itself." Citing to Waller versus Truck Insurance Exchange, a 1995 decision of the California Supreme Court. For our purposes, it is important to note that the policies are not intended to cover intangible property losses, including loss of an investment, loss of goodwill, or loss of intangible property. Close quote. This was Gunderson. The court found that an easement is intangible, so there was no obligation to defend or indemnify an insured for such intangible losses. The Kazis had purchased land adjacent to another parcel, which was purchased by a family known as the Tolkasons. Sale documents indicated that the two parcels shared a common driveway, 20 feet in width, that straddled the boundary line. The Tolkasons assumed the existence of an implied easement. The Kazis subsequently graded an access road on their parcel near the boundary line. The Tolkasons filed suit alleging the Kazis' access road obstructed the Tolkasons' implied easement over their parcel. There were two policies at issue. One policy defined property damage as physical injury to or destruction of tangible property, including loss of its use. The second policy defined property damage as physical damage to or destruction of tangible property, including loss of use of this property. Close quote. Concluding that the rights involved were all intangible, the court stated, quote, "Thus the Kazis grading a driveway over their own parcel A and the 10-foot strip they owned that was subject to an easement dispute did not change the nature of the underlying Tolkason action into an action for a tangible property loss. Grading over the insured's own land that may have been subject to an implied easement did not change the easement's intangible nature, nor could it ever change the character of the easement right-of-way that the Tolkasons claimed. It is the nature of the easement right that was issued, not the physicalities that may relate to it. As Gunderson made clear, a loss of pure rights in property is not the physical damage or injury to tangible property required to trigger a duty to defend or indemnify under general liability policies." Close quote. In Indiana, damage from an alleged defective service may be recoverable under a negligence theory if the alleged defective service caused personal injury or damage to other property, but contract law governs purely economic loss arising from the failure of the service to perform as expected. The economic losses included diminution in value of the structure, incidental and consequential losses, lost profits, rental expense, cost of repair, and costs of reconstruction. Both the economic loss doctrine and the integrated system approach should be viewed as part of the rationale for certain property damage exclusions found in the CGL form. In Mraz versus Canadian Universal Insurance Company, the Court of Appeal for the Fourth Circuit concluded with regard to response costs resulting from government orders to clean up hazardous waste that, quote, "response costs are not themselves property damages. An examination of CERCLA's provisions defining response and authorizing the President to take response action makes it clear that property damage and response are independent. For example, the government may take response action in case of substantial threat of a release of a hazardous substance before any damage actually occurs. One cannot equate response costs with injury to or destruction of tangible property, this policy's definition of property damage. Instead, response costs are an economic loss." Close quote. Since the court concluded that response costs were not property damage to tangible property, the insurer had no duty to defend or indemnify. Now, courts will work to find coverage for defense if it is logically possible. Therefore, construction defects in a house that damaged the house itself constituted property damage sufficient to trigger the duty to defend or indemnify under a CGL policy. A party that has incurred its own response costs to clean up contamination may also be entitled to bring a cost recovery claim under CERCLA Section 107 for those response costs. However, in essence, an insurer that is only obligated to reimburse the insured for cleanup costs does not itself incur response costs. Therefore, if response costs are paid by an insurer, it is necessary for an insurer to seek reimbursement of the response costs paid from the U.S. government available to the insurer by statute. The plain statutory language and overall scheme of CERCLA indicate that an insurer cannot bring a subrogation action when it has not itself incurred response costs. As the Supreme Court has observed, quote, given the clear meaning of the text, there is no need to consult the purposes of CERCLA at all, as it is ultimately the provisions of our laws rather than the principal concerns of our legislatures by which we are governed. It is a settled rule that the insurer must look to the facts of the complaint and extrinsic evidence, if available, to determine whether there is a potential for coverage under the policy and a corresponding duty to defend. Further, it is well established that even after a valid initial denial of defense, later developments may impact the insurer's duty to defend, and a bare potential or possibility of coverage is the trigger of defense. In Chubb Custom versus Space Systems, the Ninth Circuit explained that response costs are deemed necessary when an actual and real threat to human health or the environment exists, because the statute does not define incur in the context of response costs, and there's no controlling authority on the term in the CERCLA context. The Ninth Circuit applied the ordinary meaning, which is to acquire or come into, to become liable or subject to as a result of one's actions, to bring upon oneself. The Ninth Circuit found that both the plain statutory language and the overall scheme of CERCLA prevent an insurer from bringing a subrogation action to recover costs it paid on behalf of its insured when it has not itself incurred response costs. This video was adapted from my book, Zalma on Insurance Claims, Part 103, 3rd edition, which is available as both a Kindle book and a paperback from Amazon.com. If you found this video interesting or useful to you and your colleagues, please pass it on. It's free. And please also subscribe to my YouTube channel, my Rumble channel, clicking on the like and the Rumble buttons as you do. And also subscribe to my blog, my Substack publications, and my locals community so that you can be advised of future videos and future blog postings. Thank you for your attention.